Texas passed a law that essentially deputized citizens via the courts to sue any person involved in the enabling of someone getting an abortion after 15 weeks in Texas, or is it 20?
I think it was 15.
And it was 20, I believe. And
15 is the Mississippi law.
Exactly.
It's hard to get all of these theocratic laws, keep them.
No, I'm sorry. Excuse me. This is at 6 weeks after pregnancy. And
right.
6 weeks after pregnancy, you can sue a provider, a taxi cab, a person who enables an abortion in Texas. You don't even have to be in Texas to sue. You don't have to be a Texas citizen to sue.
That allows well-funded money groups to aid in this effort.
The advocates of abortion rights went to the Supreme Court before it took effect in September. The Supreme Court declined because they said state officials were not responsible for enforcing the law, that it could not be challenged in federal court based on the constitutional protections established by Roe. Supreme Court, however, in December, said that opponents of the law could file suit against Texas medical licensing officials who might discipline abortion providers who violate that law. So they sent it down to the Fifth Circuit, which is in Texas. That circuit is a pretty conservative one. The judges in the Fifth Circuit said, we're going to kick it to the Texas Supreme Court to make this determination. And the Texas Supreme Court yesterday, or I should say on Friday, all Republicans, shockingly enough, said that those officials, the Texas medical licensing officials, did not, in fact, have any power to enforce the law, either directly or indirectly, so could not be sued. And so this law stands, which has two different impacts. One, it has an impact on the ability of women in Texas to get abortions. Apparently, they've been trying to get around it by ordering pills, abortion pills, through the mail and going to other states. More on that in a moment. It also essentially says that the way you get around violating constitutional rights in a state, or effectively taking them away, is by empowering citizen vigilantes using the civil courts as a way of inhibiting people's ability to help, aid, fund, perform, in this case, abortions. But I don't see why it couldn't be anything at one point.
Well, and they're also dangling a bounty of sorts. In Texas, it's $10,000 if you're successful in your court case. But as we'll get to in a bit,
there's going to be businesses set up to do this. Mm-hmm. There's
a profit incentive design inside of the law. That is the whole purpose of it.
People are going to have a job, and my job is going to be to find out who had an abortion.
And if you have an accumulation, or if you have like a good amount of capital at your disposal, you can take on these cases en masse. Why not?
Yep. So where else will this end up being a problem? Do you want to talk about Idaho?
So Idaho has now passed a copycat law based on Texas's law. It's a bit different. The bounty is 2 times that of in Texas, and this seems to be a bit more targeted towards providers. This is from, I believe, the New York Times.
Yep.
The Idaho bill differs from the Texas law in some key respects. Texas allows any civilian to sue anyone, whether a rideshare driver or a doctor, who aids and abets a woman getting an abortion after a fetal cardiac activity is detected usually around 6 weeks, before many women are aware that they are pregnant. It provides $10,000 plus legal fees for successful suits. The Idaho bill, similarly titled a heartbeat bill, allows family members of what the legislation calls a preborn child to sue the abortion provider and establishes a reward of at least $20,000 plus legal fees, at least $20,000. It allows lawsuits against providers for up to 4 years after an abortion. So that's a strong or like a long period of time when they would be able to retroactively sue for damages caused by an abortion, I guess. The Texas law, considered the strictest in the nation, allows no exceptions for women who are victims of rape or incest. The Idaho bill provides an exception, but requires women to file a police report or show it to the provider before they can get an abortion. Neither state would prosecute women who have an abortion. Just anybody who aids and abets it, essentially. And the Idaho one is really just targeting providers, doctors, nurses, people, nonprofits that might be trying to increase access to women's healthcare throughout the state.
It also limits who the plaintiffs are to just family members. So that could be mother, grandparents, siblings, aunts, and uncles of the preborn child, they call it. I mean, is it really just a time? I mean, what about if people masturbate? What about when people have their periods? Weren't these all, I mean...
That is the releasing of an egg. That could be a preborn child.
I mean, aren't you negligent if you allow all those eggs to die?
But say you're in Idaho and you want to go to a nearby state, right? Well, maybe you'll be able to get that, but other states are starting to crack down that as well.
One other note about this bill in Idaho, it obviously also allows the father. However, not if you are a rapist. A rapist cannot sue after an abortion is performed. But I wonder if a rapist's mother or father could sue. They're a grandparent.
Good point.
Could a rapist's brother or sister sue? I'm the aunt of that child. I want to sue.
And let's be clear, too. The rapist in this case would have to likely be proven as a rapist in the court of law, as opposed to just like the millions of rapes that are unreported.
Right. That's right.
And that's why Idaho says you've got to file a criminal complaint. You got to speak up. If you have any trauma that you've internalized from, like, I don't know, the rape that you just suffered, if you don't document it, it doesn't count. Say it's a family member and you're worried and you have anxiety about, I don't know, bringing a criminal charge against a family member. If you didn't criminally charge them, it doesn't count. Not exempt.
It really is. I mean, you could just look at what it does to rape victims in and of itself and see how barbaric this is. For women who do not bring charges are essentially forced to carry to term a rapist child. And again, it doesn't allow rapists to sue, but it could allow the parents of a rapist, because they are grandparents of the unborn. Yeah,
are you depriving me of my unborn child? You depriving me of my unborn niece? I mean, like, so the ownership that these like people feel over the reproductive consequences of other women just because they're familially associated with them is just so creepy and weird that it's hard for me to even stomach.
So the other option, of course, is to seek an abortion out of state. Washington Post reports just the other day, last week, I should say, prominent anti-abortion lawmaker in Missouri. Thousands of residents have traveled to next door Illinois to receive abortions since Missouri passed one of the country's strictest abortion laws in 2019. Believes she has found a solution. It would allow private citizens to sue anyone who helps a Missouri resident obtain an abortion out of state using the novel legal strategy behind the restrictive law in Texas. This is going to pass, incidentally. The amendment was attached to several abortion-related bills that have made it through committee and are waiting to be heard on the floor of House of Representatives. Abortion rights advocates say the measure is unconstitutional because it would effectively allow states to enact laws beyond their jurisdictions. But the Republican-led Missouri legislature has been supportive of creative approaches to anti-abortion. Look, here's the thing. You know, like even in that Idaho ban, apparently the Republican Attorney General thinks that it might be that the new bill with civilian enforcement would likely to be found to violate recognized constitutional rights. I could bring on every legal expert we've ever had on this program, and not one of them would say definitively that any of these things could be struck down constitutionally. Now that the Supreme Court has basically said, and they all thought that there's no way the Supreme Court can allow this workaround to constitutional rights, not just federal statute, constitutional rights that would inhibit constitutional rights by simply saying, well, the state's not involved in it. All we're doing is setting up a bounty program that is paid by other people. And you can't attack the courts for doing their job. This is it, folks. This is the way that abortion gets restricted in about 22, 23 states. Now, the Supreme Court heard that case about 15 weeks. And they may also, they may fully frontally attack Roe v. Wade, destroy it, or they may just keep allowing these new laws. We need a legislature in New York or in Vermont, or I should say in any other blue state, start doing this stuff with we should do it with speech. We should do it with guns. It should go on and on and on until we show that you can deprive everyone of every single constitutional right if it's just made into a civil tort proceeding.
I thought the conservatives, don't
even bother.
I was about to say HIPAA. You know, we're not no medical privacy.
Yeah, how about this?
Or how about interstate? Or how about states' rights? Right? If somebody wants to go seek a service in another state, they should be allowed to do so.
How about we empower people? $10,000 bounty. You can sue somebody who you believe is using a fake vaccination card. How about that?
That'd be fun. There's some gun bill in California.
Yeah, that should move forward. And it should be in every state in the country that the legislature can pass it.
Yeah, you want to dance? Let's go.
But this is where we're headed. This is what happens when you give up the courts to Republicans and conservatives. That's it. And the amazing thing is going to be when that gun law comes to the Supreme Court. And we all sit here and watch the Supreme Court figure out, actually, there's a problem with this one. It's written exactly like the Texas one, except you use a preposition instead of a conjunction here. And that's, you're going to have to go back. But at one point, they're going to show up with a law that is identical, but only changes that one thing. And the Supreme Court is going to figure out some way of saying that law doesn't stand. Mark my words. It may happen 2 or 3 years from now, 5 years. Tuesday, March 15th, 2022. Keep it in mind.